Do we try? I know there were some issues like advertising and stuff, but I just wonder if like literally uh, we just yeah, just kind of just do it, not even advertise it, just do it. See how much traffic it generates. Not in a rush to
Oh,
try
it's
though.
the video is private.
Uh,
Live
it's
stream.
still it's still setting up stuff at the moment, so it's not live on YouTube yet. It's taking longer than normal. Here we go. Oh yeah, cool. I probably yeah. So it's now up. It was probably yeah, cool. All right. Yeah, welcome everyone to this week's live stream. Will's not here, so it's just me and Shannon. So neither of us are solicitors, but it's not legal advice anyway. As always, if you could refrain from putting personal data in the chat, that would be awesome. Oh, wrong thing. I was trying to put a little notice in there. That's not going to work now. Oh, I messed that right up. Already tech issues from minute one. Um, Yeah, so if you can, yeah, no personal data. So ask questions as if they're about someone else. You'll get exactly the same answer, and you don't have to spill your beans all over the internet to get that answer. And also, in my experience, it helps people isolate what the actual issue is they need to know from a legal point of view, as opposed to all the other things you're going to be dealing with at the same time. Because in one sense, the legal bit's the bit we can help out with. Um, so let me just write it manually here. Please do not share personal data in the chat. There we go. Not cat, not hat, but chat. Yeah. Okay. Um, and yeah, just the order we do this, we've got 6 questions coming through the week. We're going to prioritize questions that are actually anonymized. So there are 4 questions which are not anonymized. We'll do them last. So we'll do the anonymized ones first from the week, which are 2 questions. Then we'll look at the ones in live stream. So I see there's a question already come in. We'll get to you as soon as we can, basically. Otherwise we just kind of lose track of what the hell's going on. I feel like I've forgotten something else, but we'll figure it out. So yeah, done that. So me and Shannon were just talking just at the beginning there before we started about obviously this has been a really shit week for England in terms of how divided everything is, and my views are that housing supply and things like gatekeeping play a role in that somehow. So if we get time at the end, we're going to see if there's a way of kind of talking about it in a way that doesn't throw petrol on the fire, basically. So yeah, so just if you want to hang around for that at the end, to be interested to see if anyone's got any ideas about the topic in general, but without just ranting about immigrants because it doesn't help anything, doesn't change anything. So yeah, question one, and let me just get up into our little virtual flip chart. So here we go. You see it, Shannon? Give me a nod. Yeah, cool. Right, question one. What if you had domestic violence, domestic abuse abroad, and were in exile by virtue of homelessness in UK and have no evidence from, for example, the police? So let me just collapse this down to make it a bit tidier. So yeah, basically, I mean, it's a yeah, I'm sure this situation happens. It does happen. The answer is always going to be the same in the sense that it's better if you do have evidence from a pragmatic point of view. But legally, if I'm just going to show you, let me just share a different screen actually. So I'm going to show. I just googled LGO decision about gatekeep. Yeah, LGO decision about domestic abuse. Here we go. So if you put that, I know, can you see that, Shannon? Yeah, right one. It says, "How is your council performing?" Yeah, so that's the LGO's website. Um, and basically, yeah, it's just a Google search. If you then go to the focus report, now bear in mind there are loads of focus reports in here. They're all really good, but there's this one here about domestic abuse. If you work in a sector or you're affected by domestic abuse, I would highly recommend you read it because there's loads of information in there which are going to help you out. So where are we? This is what it looks like at the top. We go back a little, yeah. So you kind of got what the law kind of says and just kind of examples of things that councils have got wrong. So this report was done about 6 months after the Domestic Abuse Act 2021 came in. And if we go down to page 14, there's a really, really important bit in there. So if I was Googling this, there we are. So local councils' default position should be to believe people who disclose they've been abused. Um, And so, and it kind of talks about, so back here, so officers should have been trained about it, understanding the different types of abuse that kind of different forms it can come in. And also kind of makes this point. So downplaying or doubting abuse suffered by a victim risk adding to the trauma they've already suffered, and at worst repeating the pattern of abuse they've experienced. So my opinion, this is a great LGO report, by the way. The one we talked about last week or the week before about medical evidence was a lot weaker than this, but I thought they got this really, they did a good job here. And it kind of talks about the Homelessness Code of Guidance as well about that stuff. Now, so the answer from the LGO is you should not need police evidence from a professional or whatever to prove that you're being abused. That's not the question that the councils have to answer. They just need to kind of, go on the balance of probabilities. And someone saying that they've been abused should be enough to kind of, should be enough for the council to be satisfied. They can ask other questions. And as I say, it is helpful to have that other information at hand. And it doesn't have to be from the police. It could be from a family member or from support network, or, potentially like, I've children's centres and kind of nursery workers, that sort of thing can also have information that's going to help out. But that is kind of the way council should behave. And that little excerpt I've quoted numerous times to councils when they've started doubting stuff. And, started saying things like, oh, yeah, well, you need to have police evidence. And in fact, if I just get the Homelessness Code of Guidance up, which kind of makes a similar point, it's probably not quite as strong as the LGO. Got to find as always, we're in the same thing where it's just shuffled my entire desktop, and I can't see the Homelessness Code of Guidance to hand. Here we go. So yeah, once again, I was going to share my screen and then try and make sense of it. So this is what the Homelessness Code of Guidance looks like. It's not very snazzy. It's got all the amendments there. And then if we go down to chapter 21, which is all about domestic abuse. So, again, if you work in a sector, you need to really read this because it is great. And also, I'm just going to see if I can find the actual chapter. So I'm just going to put blanket approach into the search. So that should find it. And I'll spell approach right, so that'll work as well. So here we go. Yeah, 21.24. So if we go down to the bottom there, housing authorities should not have a blanket approach towards domestic abuse, which requires corroborative or police evidence to be provided. So again, I've quoted that a lot, where whenever you've got a council officer insisting that they have evidence, then you just kind of throw that in there. But it does make things smoother if you've got it. So yeah, so that the answer to that question is you shouldn't need evidence necessarily, but it will help. And so you can expect a pretty rough ride, to be honest. If the reality is the law's pretty good, council officers' practice is pretty terrible. So what a lot of people say go through the system is actually it's pretty horrendous. So if you can get a support worker or some sort of supporting professionals to help you out that journey, that's probably going to help you out. Shannon?
Yeah, well, they need to pass the habitual residency test. That was a mouthful. Because obviously, if they've been living out of the country, I know there was recent changes, and I've just been trying to look it up. 7.22 of Code of Guidance might be relevant here, but sort of if you've been outside of, say, the UK, Channel Islands, Isle of Man, or the Republic of Ireland continuously during the 2-year period prior to the housing application, it looks like you might then have to sort of pass that habitual residency test, or it's down to the local authority to sort of make further inquiries, whereas before you would just be like, yeah, 2 years beforehand. So I guess it sort of depends on the length of stay out of the country and the other sort of circumstances in like what country it is and how long and
Yeah,
plans to move back and everything else.
so people
I
are
just
not
wanted to make
eligible.
it, yeah.
Yeah, people who are not eligible for assistance can't get anything from really of use for the Housing Act. You can get advice and assistance, but that doesn't involve actually housing you. So if you go to the last, this is like the last bit of the Homelessness Code of Guidance. You've got the length of residence in the UK. So and it basically, I mean, I'm not going to read the whole thing out, but basically, I just highlight this bit here. So the appropriate period of time need not be lengthy if the facts indicate a person's residence has become habitual in nature at an early stage. In some circumstances, the period can be as little as a month. Now, again, I've heard housing officers say, "Oh, it has to be 6 months." It doesn't have to be 6 months.
Yeah.
So yeah, so in effect, for someone in that situation who has been, yeah, Shannon says, kind of living outside the UK for a long time, then actually, before you even get to the question of domestic abuse, you've got to cross the hurdle of actually being eligible for assistance. So yeah, that's again, yeah, kind of you need to deal with those two issues separately. So, you know, kind of one at a time. And I guess technically, just to kind of drill in what the law says, if you approach a local authority and there is reason to believe that you might be homeless, might be eligible, might be in priority needs, then they shall provide you with interim accommodation. But then their next job is going to be to work out if you actually are eligible for assistance. And this is where the HRT, the habitual residence test, will come in if you're in certain circumstances. So yeah, but hopefully that's kind of some useful stuff in there anyway. Um, oh, Struth, I've just seen the live streams kicking off. You all right, guys? You all right, Jackie? So yeah, again, I'm just going to check. There's nothing we need to respond to right now. You all right, Ramina? Yeah, so just question. So yeah, you can ask questions about homelessness law in the live chat. I guess that's why it's there. But we will come to it in turn. So we're going through some questions already that we've come through the week. And please do not share personal data. So if it's about yourself, that's fine. Just make it out as if it's about a hypothetical person. So you know what would happen if if someone was told they had to stay until the bailiffs came. That's a good question. If you said I've been told to wait until the bailiffs come, I'll just delete it. So that's the way it works. So yeah, anyway, that's question one. Let's get back where we're up to. Question two is on the way. When I just copy and paste it in. So this is a pretty snappy question, which is nice. Like these sort of questions. So do your points go higher if you go down the homeless route, and can you still bid? Now that might not mean anyone to some people because it's I appreciate there's some jargon in there. But what that person's basically asking is with a housing register, so you kind of you'll bid on properties, you know, kind of you'll get given points or you'll get given a banding depending which council you're in. And they'll depend on your circumstances. So if you've got medical needs, if you know if you're a transfer applicant, if you're underoccupied or something like that, then you'll get quite a lot of priority. Now, for a lot of people, they'll actually have applied to the housing register long before they become homeless. So housing register is part 6 of the Housing Act. So that's kind of there's some generic rules that apply to all English councils. However, the rules mean that councils set up their own policy, so every council is different. So we're not, I can't tell you if your points go higher or not. But then, if you were to become homeless at some point during that period, so you know you've applied under Part 6, maybe you know you're overcrowded or something, but you weren't so overcrowded that you were homeless. But then let's say Mrs. gives birth or something, so now you are, it is now not reasonable to continue to occupy. So you should then be dealt with as a homeless person by definition. That's how it should be. You should be potentially offered interim accommodation if it applies. But what can then happen is your banding gets completely changed. And in some councils, your banding would go up if you're homeless because they'll prioritise homeless households. But in some councils, your priority will go down. And it just depends on the nature of, what kind of council you're dealing with, basically. And I think I haven't really seen a kind of generic kind of trend or anything. So there are some London councils that will basically penalise you for going down the homeless route. We always talk about Buckinghamshire Council policy because I think they've changed it now. But before, you might have been in Band B under Part 6, and then you become homeless. You drop down to Band E, and then if you were then owed the main housing duty, you go up to Band D, which basically means, let's say for example, someone was on the housing register already because of domestic abuse, which meant they're homeless. They would be disincentivized from actually telling the council they are experiencing domestic abuse because it would have this negative impact on their application. So it's messy. As we always say with these kind of questions, if you Google the term housing allocation scheme and then your council's name, you'll get the policy, and you just have to read through it. There's no substitute. There's no quick way of doing it. You have to read through the policy to see how the points are set out, and essentially to work out what impact being homeless has on those points. As I say, sometimes it'll be better, sometimes it'll be worse. Shannon?
Yeah, I think it's just important to make the point that the only benefit sorry, start again, Shannon. Being higher up on the sort of bidding system isn't necessarily the only benefit. So if you're in, say, one of those local authorities where actually you go down a bidding band because you've made, a Part 7 homelessness application, there are other benefits to that. So stuff like interim accommodation, suitability reviews, personalised housing plans. You don't get that with sort of Part 6 applications. So even though you might be higher on the banding, it still might not be best for your situation. So that's why it's important to not just read sort of the allocations policy, but to read into sort of or to ask a local authority, actually, if I make a homeless application, what do I get along with that? Because I think a lot of people see like the waiting times, and understandably they want to move quick and fast, and they think, I'm going to get social housing quicker, but it might be less suitable. Um, just you don't know is the point until you do a bit of research, and it is worth spending some time. I just want to make that point because on the face of it, otherwise people would go, well, why would I make a homeless application if I got high abandon? Actually, there's other benefits that the homeless application process gives you. Um,
Yeah.
I don't know if that made sense.
No, yeah, it doesn't. There's other negatives as well. So if you go
Yeah,
down the homeless route, and that, as I say, going down the homeless route is just jargon for saying telling the council that you're now homeless or you're about to become homeless, because you should then be dealt with under Part 7 of the Housing Act, which is going to be either the prevention or the relief duty. Now, another downside of that is that if you go down the homeless route, there's no guarantee of getting social housing, and then they might discharge their duty into the private sector, which is yet another bit of jargon. But basically, a lot of people haven't, kind of are still under the impression that if you make a homeless application, you'll be guaranteed social housing. You won't be, even if the council owes you the main housing duty, which is the best duty they can have. They can still discharge that into private rented accommodation. Yeah, and I guess this is part of the reason we do these live streams, which is this is an area we can't really go into much detail because every area is different. But one of the big problems you guys are going to have is there is no guarantee that any of the local professionals will actually understand any of this. So the only people who might know how the housing allocation scheme works is the senior officers who wrote it, and then housing officers at the council, and then voluntary sector workers to an even greater extent they just won't understand what any of this stuff is. So do your research as best you can. There is no subject for reading through that policy. One of the duties councils have to everyone, whether you're eligible or not, is they have to give you advice and assistance. So Shannon says you can ask the council, these are my circumstances, or what if these were my circumstances? What would the council have to do? And again, that's what the law says. What happens in practice is councils just will probably ignore that email forever. So you have to complain even to get that basic advice. But that's again, as we always say, if you can get a competent support worker or even better, a solicitor, they're going to be the ones who actually probably have a better understanding of how it all works. So yeah, I think that's probably that might be all we can say about that one. But it's an important issue. There is even more to say about it, but I think we're going to overcomplicate things if we go down that route. Cool. Then the third question is coming through the week, and then we'll get into the live stream chat. So what if social workers talk on your behalf to homeless managers and still don't agree? So this often happens. You might be, you're under social services, and your social worker helpfully talks to the homeless managers, and the homeless manager or homeless officer doesn't actually follow, doesn't listen to what the social worker's got to say. So this is common. There's a number of issues going on here. One is that social workers don't get training on housing law, so often they don't know what the law is. They won't know what the housing allocation scheme says, and so they might, talk until the cows come home with the housing officer. If they're not right about it, then they've got no chance of being successful in kind of helping you out. But even if they are right, even if they do know what they're talking about, this is very common within councils where their colleagues, they just won't work together. They will literally just play tennis with a client until someone else pays for that person's support. So again, if you're a social worker, you've got a really good you're in a really good position to actually get some good outcomes with this stuff. But you do need to understand what the law is, and you also need to kick up a fuss, because one of the maybe the most common issues is where a family is told that they're intentionally homeless, then gets referred over to children's services, and social workers don't know the law well enough to actually go back to housing and say, what the hell are you talking about? This family is not intentionally homeless. And so that they're kind of there by not understanding the law, social workers make their own jobs much harder. So yeah, Shannon.
Yeah, so I read this differently, but apparently it's going to be one of those nights, guys. So apologies, and thanks to Mike for carrying tonight's session. I read it as in like the client doesn't agree, and so it says a lot about what I think about the sector. But and the social worker and the homeless manager were making decisions on the client's behalf, and the client didn't agree. At which point, I would say you need to like get in writing what it is you think you need. This process should be a collaborative approach. That's in the code of guidance somewhere if you search for it. And there's some good stuff in sort of like social care around, actually the client needs to be involved with the decisions. So if that was the case, which I don't think it is, but you as a person and an individual have a right to be involved in what's happening to your life. And I think we've both seen it where maybe not social workers, but support workers and sort of housing staff at the team and stuff do sort of pressure people into supported accommodation or whatever it might be. Even though you're sat there going, oh, I don't really want that. I don't think I need that. So I'd just say, like, it's hard, but try and advocate for yourself in that situation and make it clear why you don't think you need that or why you do think you need something, and yeah, get other professionals involved if needs be as well.
Yeah, one of my many criticisms of professionals in the sector is they think they have a right to choose what their clients want. And you see it, maybe the best or the worst example of this is in Marek. So the domestic abuse risk conferences that take place, where in theory your IDVA is the person who is supposed to articulate your views and advocate for you. But the key thing is you can't be in those meetings. So you basically don't have an opportunity to say what you actually think, what you actually want. It's all done kind of, Chinese whispers almost. And so you can have situations where some pretty unpleasant professionals end up making some pretty important decisions about what's going to happen. The Data Protection Act is your big friend here, because you are allowed to request any records that relate to you for free within 30 days. So when I say within, the council's got within 30 days to actually respond to your request. And by doing that, you'll often see what if any reasoning actually took place. So again, it's sadly you've kind of, as Shannon says, you've got to advocate for yourselves. You've got to stamp your feet sometimes and actually exercise your rights, which, yeah, just seems to be something that as a I don't want to get too much into this immigration stuff. As a nation, we don't seem to have been taught to enjoy our rights. We have various rights under housing law and lots of other laws. But it seems that a lot of people just don't feel they're able or don't feel they're kind of entitled to kind of enjoy that protection that our politicians have basically set into the law. Anyway, it's not getting too much into that yet. So let's go back. Right, I think that's the three questions that are coming through the week. Let's get into the live chat now. So let me just piece this one together. Right, so
There's a snappy one first.
have I missed a snappy one? Oh yeah, sorry, yeah, no, I missed that. Yeah, let me right, hold on. Let's do that first. So how long will the council keep you in TA? Sadly, this is how long is a piece of string. If you're in London, you could be in temporary accommodation for 10 years. If you're outside of London, it's likely to be 6 months, 2 years is pretty typical. If you're owed the main housing duty, that is. So obviously, there's a few things going on here. So as always, we need to differentiate between interim accommodation, which is the accommodation that the council gives you between making the application and making a final decision, which should be in the region of 9 or 10 weeks, roughly, in terms of making the final decision. And then if they owe you the main housing duty, then they will basically keep providing temporary accommodation until you move into suitable accommodation, which, as I say, in the housing registers in London, that could be years.
Can I just clear something up there? Because that was a bit confused. Interim accommodation and temporary accommodation can be the same property. So I just wanted to make, because it sounded like you have a different sort of property where, when you go from interim to temporary, that's not necessarily the case. Just the name of it changes, but you could still be in the same location.
Yeah, or equally, you might be in 5 different addresses that's all interim, and then another 10 addresses that's temporary. So it's So there are a few things I'd say about this. So you can't have families with children or pregnant women in B&B type accommodation for more than 6 weeks. If the council does that, you can get between £100 and £200 per week compensation if you were to complain to the local government ombudsman. And also, let's say, for example, you're in priority need, but you're found intentionally homeless. The council still need to house you for 4 weeks, 6 weeks. Some councils probably say 2 weeks. So a period of time that gives you reasonable prospect of finding something else. So again, for a person who's in priority need but intentionally homeless, they'll still get housed by the council for 3 or 4 months, depending how the timings will work. But that's not good news. The thing you can do, which no council, basically councils should publish their average waiting times if they were sensible, if they knew what's good for them, because loads of people obviously want to know how long is it going to take. And the average waiting times won't tell you exactly how long it's going to take, but they give you a rough idea. So what you can do is you can do something called a Freedom of Information Request, an FOI, which again is similar to a subject access request where you request your own records, but you can ask certain organisations like a council, like the police, like the NHS, public bodies about information. So you could ask them, what is the average waiting time for a single person in Band B on the housing register to get housed? And the person responding will literally go on the system and it'll just tell it straight away, and you'll get an idea then. So yeah, I'm trying to think in Bedford where me and Shannon are. I think the average waiting time, if someone's main duty accepted for a single person, was something like 6 months last time I looked. Is that sort of, and I'd imagine the further away from London you are, the shorter those waiting times become, or further away from big cities you are, the shorter those waiting times become. But yeah, it's not. I appreciate that's not a terribly helpful answer, but that is the best answer we can give because yeah, there is no limit in one sense. So yeah, next question, and this is a multi-partner. Bear with me. Let's get it all in there first before we go into it. Shannon, I see 3 parts. Is that right, or is there another one?
There is one more bit just saying it's not really part of the question, but council denies the existence of any code of guidance, which isn't part of the question, but is important to acknowledge.
Yeah, right. Okay, so client is 22 days from being homeless. I guess that means so maybe they're being evicted in 22 days. They've contacted Manchester City Council homelessness team. The council told them to go back to social housing on housing's portal's medical team, a collective of social landlords who control all the social housing area. They have refused his homeless relief duty and told him to contact the housing portal because he is disabled and tell them to make him band 1. Okay, so what might be happening here, potentially, there's a number of things that could be happening. I'm not familiar with Manchester's policy. What the homelessness officer might be saying here is that actually you might be better off going directly to the social housing's portal because you'll get a higher banding. That might, I'm being generous here. They might be saying that because, as we mentioned in that second question, different councils give different banding to different kind of medical needs, or no medical need, or whatever, different circumstances. And so potentially the council housing officer might be doing you a favour and actually saying, do you know what, there's a better way for you to, there's basically a way which is going to be faster. You might get band A, and also would give you more choice over where you end up living, which is an important factor we haven't really talked about yet. But when you're under band 6, so when you don't make a homeless application, but you instead get a high banding on the housing register, then potentially you get more choice about where you end up living. However, the problem we've got here is that this person's 22 days from being homeless, and one of the big downsides of Part 6 is that there's no interim accommodation, there's no temporary accommodation offered. So what I would say, again, I just don't know the council well enough to know what might be happening here. But what I would say here is that do what they've said to start off with. Go back to the medical team and see what happens, and just see if that leads to something better. If it does lead them to being band 1, then again you need to speak to the housing officer again probably. But I would say potentially you might not want to force the homeless application until that has failed, until trying to get band 1 has failed, because you then kind of get into a whole kind of process which might be avoidable. I mean, I think it's unlikely. 22 days is probably not enough time for them to sort anything out, but they might be saying there's actually maybe a better option there. Now, in terms of the code of guidance, so there is a code, the homelessness code of guidance, which is what I've shared on the screen already. That's all about Part 7 of the Housing Act. There is also a code. It's not called a code of guidance. I've actually forgotten what it's called, but there is a code for Part 6, but it's much shorter than Part 7 because you've got your local policies which define what's what. They do kind of make some important things. They do say some important things, but yeah, I think that's my answer to that one, is potentially keep in contact with the housing officer and just say, look, why are you telling me that you haven't accepted the relief duty or potentially the prevention duty, depending on what the circumstances here. If we're talking here about Section 21 notice, then do check out the video on the channel that's kind of, if you just search for the term bailiffs, you'll get the video, which is about, being told to stay until the bailiffs come, which might be at play here as well. But I think that's potentially, as I say, that might be the best I can do here without kind of knowing their policy very well, at all. So yeah, Shannon, is there anything you think of that we can add into that one?
Yeah, I think you're probably right in terms of what housing officers saying actually is you're probably going to be better off going through that collective of social landlords. But if that is true, what I would say is if you were to say to that housing officer, perfect, I'll go do that. Do you mind just sticking it in writing for me so I can remember what I'm doing? Now, if that's legit sort of advice and assistance, they're not going to have like a problem doing so, putting it in writing. So I would just sort of make that point, and then if say down the line actually it turns out that's not true and they're sort of fobbing you off a bit, then you've sort of got that evidence of gatekeeping as well, where you've given them reason to believe that you might be homeless, might be eligible, might be in priority need, and they've sort of essentially refused to accept the relief duty. I'd say about the threat in the client being put in a medical setting right off the bat. Is this legal? Obviously, housing officers can't threaten people. Again, it might be this case though that they were saying, and it depends on the person's sort of medical needs and stuff, but actually, look, we don't have any suitable accommodation for your needs. The only option we'd have is to put you in a medical setting because that would be more suitable than accommodation with no adjustments made, for example. And I can't really think of many situations where that might apply, but it potentially could. Again, ask for stuff in writing. If they're not willing to put it in writing, then that's sort of a really good sign that they're doing something dodge. Not
Yeah.
always. Some local authorities will put everything in writing, and you think what? So yeah, that's the only thing I
Yeah,
had to add. Really.
yeah, and I guess just to kind of belt and brace these situations. So as we kind of always say, involve your councillors, involve your MP, all at the same time, so they can all see that. Yeah, because there's a lot of obviously kind of politics that goes on. Kind of out competing each other. If they can see that you've emailed the whole, so that your local ward councillor is the MP, potentially the councillor who's overseeing the housing issue, potentially the councillor who's overseeing adult social care, if that applies here. If you're making, if you're basically contacting them and just saying, look, this is my situation, keep it nice and brief, bullet points that, this is where we're at. This is what I've been told by Manchester City Council. Can you provide any advice here? That would potentially, it certainly wouldn't do you any harm. And I think as well, you kind of start distilling out what the council officer's actually trying to say by, as Sharon says, by putting it in writing and kind of making it, kind of on the record by doing that. And kind of what councillors do is they basically add to the kind of the accountability that officers are under. Otherwise, like housing officers will quite often do some very bad things if they think they can get away with it. But involving a council or involving an MP is, they might seem like they're useless, but their eyes on the situation is not going to do any harm. There's just a follow-up question from whichever one it was, 2, no, 4. So I think it's so if interim accommodation is different from temporary accommodation, how do we know the difference? So good question. And again, it comes down to whether the council's following the law. They should be basically providing you with a series of letters as you go through the homeless application process. And so the first letter you'll probably get is, you've approached the council on this date. We are accommodating you under section 188 of the Housing Act 1996, part 7, and it will give you all that legal blurb just to make, intimidate you really. But so if you see those words, or that term, section 188, then it's interim accommodation. When they then make that final section 184 decision, just to complicate things, it's either going to be section 190, which would be the duty to people in priority need but intentionally homeless. So it's going to be a short-term duty, but it's still going to be a duty. Or section 193, which is the main housing duty. You'll also get letters which mention section 189A and section 189B, which is the assessment, the personalised housing plan, and the relief duty as well, just to make things super complicated for no reason. But those, so if you're in accommodation and there's any mention of section 188, then it's interim accommodation probably. And if you're in accommodation and there's mention of section 190 or section 193, then it's likely to be temporary accommodation. But as I say, some council officers won't email you these or won't send you these letters when they need to anyway. So but yeah, again, if you're ever in doubt, email the council officer and say, look, what's occurring? What's my rights here? What's because it does affect how secure it is. Interim accommodation can be ended after a few days if they decide that you're not in priority need or you're not homeless or something or not eligible. Whereas if you're in temporary accommodation, there's a bit more security to it, as in they can't just kick you out straight away. So yeah, so I think that's probably how I'd answer that question.
Just one small thing to add is sometimes those letters, the local authority don't send them to your interim or temporary accommodation address, and they'll actually keep it in the local authority's like council building. So it's worth checking with your housing officer where is correspondence going to be. Now I know obviously like since COVID as well, a lot of things are now emailed, but it's worth just checking actually where is that information going, because I've certainly had clients where it's like, oh, it's been in the office for 10 days, and you're like, well, that's of no use to anyone. So it's worth checking that.
Yeah, and I guess just ask, I mean, wherever possible, asking that officer to email you and copy in support network if you have any support network. There's no reason why officers shouldn't do that. It's easier than sending out a letter. Cool. Number 7, what would happen if someone is pregnant and they have a child under 2 years and a husband who earns 35k a year? Their current landlord has issued Section 21. They're applying elsewhere for private accommodation. There's a bit more. Hold on. However, only one person works. Can they still apply for housing as they can't secure private accommodation due to skyrocketing rent prices? So
there's more to that.
Oh, sorry, there's more. Hold on.
So would the council help with priority housing in this situation? They can't find any accommodation that's in the range they're currently paying for a 2-bed. And Section 21 gave 2 months notice to evict the property, and then letting agents as well. So there's quite a few more.
Yeah, just bear with me. Let's piece it together.
Yeah.
Shannon, do you want to start answering it whilst I just extract it from the chat?
Yeah. So if someone's pregnant and you have a child, you would automatically be in priority need. So you're automatically ticking that sort of interim accommodation duty. The current landlord's issued a Section 21. So depending on how close you are to that Section 21, you are also at risk of homelessness. So you're ticking that might be homeless box. I'm trying to read it as well. This is why you read out the question before answering it, isn't it, Mike?
Yeah.
Look, every day's a school day.
Yeah. I'm sorry. Where do you get up to? Shall I read out the rest of it?
Yeah. I got up to issue Section.
Let's start again because I was multitasking there. Right. So what would happen if someone was pregnant and child under 2, husband earns 35k, Section 21 has been issued. They've basically haven't been able to find somewhere in the private rental sector, which is not that unusual. In this situation, they can't find any accommodation that's in the range they're currently paying for 2 beds. Section 21 gave 2 months' notice to evict. Right. So denying their applications, landlords prefer couples to be. Also, landlords don't like children, as a general rule. There was a famous private landlord a few years ago called Fergus something. He was like down in Kent. He was like the nation's biggest private landlord, and he issued guidance to staff basically with a list of people that he didn't want to be housed. There was plumbers were on the list for some reason. Indians, I think, was on the list. It was overtly racist and ridiculous. You can Google it. He's kind of, there was some stuff went on around it, but yeah, I'm pretty sure like battered wives was on the list as well, and kind of single mums with kids and stuff. So there was kind of landlords don't like kids or whatever. So yeah, so sorry I don't know where Shannon got up to there, but basically, yeah, if you are going to be homeless, this is why the homeless application process exists. Is to be a safety net. So it sounds like this person or this family are not intentionally homeless, and they're in priority need. So if they generally can't find something else, then yeah, let the council know. If you look on the YouTube channel and look at a video called "The Best Way to Make a Homeless Application," have a look at that video because that's how I would do it if I was homeless. All the different steps you want to take to actually make sure maximize the chance of getting help. And there's another number of things that council would have to do now. If you've got more than 16k savings, then you can't get any housing benefit at all. And if you've got more than 6k savings, then your amount you can claim is impacted. So I don't know if that's going to apply here. Probably not, to be honest, because 35k these days is probably not enough to be putting money away. but yeah, so you can absolutely go to the council, and even if you didn't kind of go through the whole homeless application process, they might be well, they will be in contact with private landlords. They might be able to get you onto the housing register, kind of quick, smart. There would be other things they can do that, any competent housing officer would actually be pretty helpful in that situation. So I think, is that the question? Can you go to a council? Is that essentially the gist of this question? I'm just going to look at.
I think so, which does make me feel better
Yeah.
because although I fumbled at the mere prospect of answering a question on a live Q&A, I think I did answer it. So yeah, I think that is the question. Would they help with the sort of housing?
Yeah. So make a homeless application, and yeah, watch the video on the channel. Do it that way. Only do it that way, because otherwise, yeah, the reason I put that video on there is because if people don't do it that way, it just leads to confusion and a bit of a mess down the line. So just do it that way. Just follow all the steps, and just kind of hopefully you're going to get help. And I guess, the bottom line is, even if the council, accept there's a duty to house you, it's still going to be a rough process. So it depends whereabouts in the country you are. If you're in London, you're going to probably end up in the short term in B&B accommodation. You're going to have lots of stresses about, where does your furniture and your belongings go. Councils also have a duty to protect belongings if you can't do it yourself. So yeah, so if you can avoid it, then obviously avoid it. I mean, everyone knows that, right? No one's kind of thinking, oh, what, homeless application is going to be brilliant. It's not. It's going to be hard, but it does mean you won't be on the streets, and it could lead to, it should lead to offers of suitable accommodation for you, if you haven't been able to find something else. So yeah, right. Let me see where we're up to. There's a two-parter here. Number 8. So that's the first bit, and here's the second bit. So a friend moved to another borough for supported accommodation, but has no local connection to the borough. But she also can't join previous boroughs registers as she hasn't lived there for 2 years now. How is it possible to have no local connection to anywhere when she's only been homeless, in the homeless kind of sector for 9 months? So, yeah, just a good question. So basically, let's just go back to first principles. Part 6, part 7, they're the only parts we have to worry about. Part 5 doesn't matter. Parts 1 to 5 we don't care about at all. But part 6 and part 7 of the Housing Act 1996 we definitely do care about. They both use the term local connection, and they both mean different things, even though they use exactly the same term. So under part 7, as in for people who are homeless or might be homeless, this person would have local connection to the new borough if they were to lose that. So if they're, let's say they got evicted from the supported accommodation tomorrow, they could approach that borough and they would have local connection to that borough. And so, yeah, but at the moment they're not homeless, they're still in supported accommodation. And what that means is that, yeah, the part 6 definition of local connection is being applied, which the closer you get to Hillingdon, the longer it's going to be. So in Hillingdon, you've got to have lived there for 10 years, basically. If you go to Dover, it's only 6 months under part 6. So yeah, you'll need to check out what the local connection policy is. And there's no kind of nothing to be gained by me whinging about supported accommodation, but I can't hate it anymore. This is one of the reasons why, because people get told, oh yeah, it's going to be brilliant here, move in here, and then your housing options get immediately slashed, and now you're stuck because you can't make a homeless application. You're not homeless. If you were to abandon the supported accommodation, you'd probably be found intentionally homeless. Probably not always, but probably. And so basically, the charities and the organisations that run these projects basically make people's lives worse. They cut people's options down as a general rule. I know there's some good support workers out there, but the system itself basically cuts down your options. So yeah, so what might be the case is that the supported accommodation provider has a specific kind of route into the part 6. So let's use Bedford as an example. And Shannon, correct me if I'm wrong, but for commission services in Bedford, once you've lived there for, I think it's 12 months. If you've lived there for 12 months, you'll get onto Band B of the housing register if you keep your nose clean, that sort of thing. But that's just commission services. For non-commission services, which a lot of supported accommodation are these days, a lot of cowboys out there getting a lot of money for it, potentially there'll be no such exemption. And so the council will say, well, it's not our fault that the supported accommodation has done this. It's the supported accommodation provider's fault. and the council's not going to try and be helpful. There's probably more to say
Yeah.
about this, but yeah, Shannon, do you want to? Yeah,
I guess it's probably worth saying, like, commissioned services, you can have big name charities aren't commissioned. So we're talking like YMCAs aren't always commissioned by the local authority, or Emmaus's, or we've got Amicus locally. I've mentioned three now, so I feel like I'm safe. But like, they're not just because they're a big name doesn't mean that they're always commissioned. Sometimes they'll still be non-commissioned, which means it's a big name, but you don't get that local connection still. So it is worth, yeah, checking that. And it's not easy to check. Like, you have to ask the local authority, probably under an FOI, to work out what's what, because I don't know if even the workers within the charity would potentially know. Sometimes they would, sometimes they wouldn't. But yeah.
Hey, I just got a little person whinging at me through the door. It's right. I've shooed him off. Yeah, cool. Yeah, yeah. So exactly what Shannon said. Yeah. So I mean, okay. So that's all very kind of all well and good. What do we suggest to a person in this situation? Well, I guess find out if there is a kind of specific route into the housing register. So if it is a commission service, and yeah, they'll have a move on policy, and that will basically say, yeah, you've lived here whatever 9 months, 3 months time. Let's, as an example, you'll be able to join the housing register and you'll be able to get long-term housing in this borough. Even if it's not a commission service, still ask if there is a move on policy, because they should have one, but a lot don't because they're cowboys. And just see what that says and see what kind of support is available. Now, this is tricky what we're about to say, but it can be done. So Shannon's worked with clients before where it was with a pretty shady supported accommodation providers, and this was the situation. The person just getting on really badly, they hates it, not good for their well-being. There's two arguments you can make to basically make them homeless. One is that you get supporting medical evidence from a psychiatrist or a psychologist or something to explain how how that environment is affecting that person. So without naming the organization locally, there's one organization where there were multiple deaths in the kind of supported accommodation. There's really poor quality of support, and understandably it had a really negative impact on people. And so what we were able to do is, what Shannon was able to do, is to basically negotiate with the supported accommodation provider to provide a no-fault eviction, effectively, just to say, look, this person's support needs are either too high or too low for this project. It's nothing they've done. They haven't broken any rules, but we're evicting them. And that then basically triggers the homeless application process. Or if you can't negotiate that with the landlord, then you would potentially be able to make an argument to say that it's not reasonable for them to continue to occupy because of the impact it has on their mental health. But that is a high hurdle to cross. It's not easy one to kind of argue that one successfully. The legal argument is you need to have a disability, and that disability needs to be made significantly worse by the current accommodation for that argument to work. So it's probably going to be easy to negotiate with the support accommodation provider. As a kind of maybe a random bit that might be helpful, potentially this person would still have local connection to the previous borough under Part 7 as well, because under Part 7, so the homeless application route, you have local connection if you've lived in an area for either 6 out of the last 12 months, so this person's lived in 9 months in one area, so they've got local connection there, or 3 out of the last 5 years. Now, again, mathematically, this becomes a bit tricky, but if they have lived there for 2 years, just less than 2 years, let's say, then they would still have local connection under Part 7 to their previous local authority. But at this point in time, this person's not homeless, so that doesn't kick in until the person becomes homeless. And you have to kind of do that in a way that's not going to leave you to be intentionally homeless. So yeah, as I say, it makes me angry that supported accommodation does this to people and doesn't tell that it's doing. They won't tell this person. I won't tell people in this situation, this is the impact of you moving in here. They'll promise them the earth and say, yeah, we'll help you get moved on and all that stuff, and it just doesn't materialize. And then you get people just getting stuck in supported accommodation for years and just going, losing their mind a bit. So yeah, how you right, Fifi? So hopefully that's useful, if not particularly positive. So next question, which is just about anonymized. So fair play to you. So someone's in priority needs. in council B and B, just 6 months after eviction, council makes decision of intentional homelessness. So what to do next? Okay, so as I've already said, in this situation, you're in priority need, but the council saying you're intentionally homeless, therefore Section 190 applies, which means they've got to continue to accommodate you for a period of time that gives you a reasonable prospect of finding something else, which is going to be about a month. You immediately need to challenge the intentional homelessness decision if there's anything in it which you don't think is right. Now, it might be absolutely you aren't, you know, you might have just knocked out your last landlord and burnt the place down. Okay, you're probably going to be intentionally homeless. There's no point arguing it. But for most people, it's quite difficult to be intentionally homeless. Let's just kind of pick out a couple of bits from the code of guidance just to help us out here. You go on, Shannon.
Oh, it's just no, because I feel like last time we had Will here for this bit, and and it was complicated, and I can't remember where we landed on it. But when someone gets evicted, actually, if it's a Section 21 eviction, can they be intentionally homeless because their reason for homelessness was the eviction? Therefore, that's not on them, so they potentially couldn't be. I feel like there was some weird parts to it.
No, although it's called a no fault eviction, you can be found intentionally homeless from it because what can happen is landlord, let's say you don't pay the rent and the landlord then says, well, I can't be bothered to go down Section 8, I'm just going to go down Section 21 eviction. So what the council would do is they'll talk to the landlord, and if the landlord says, yeah, do you know what, they're rubbish tenants, then the council will just accept that as being fact.
That was
so you need to challenge it.
Right,
yeah.
Okay.
So there's a couple of defences against intentional homelessness which we'll look at here. So 9.7. So basically says that you are intentionally homeless if all of the following apply, and it has to be all three. So firstly, you've deliberately done something or not done something, like you haven't paid the rent or you punched the landlord in the face or whatever. So that's the first thing. Seems obvious. Secondly, the accommodation is available, has to be available for you. That's probably going to be the case. But the third one is it must have been reasonable for you to continue to occupy the accommodation. And let's say, for example, you can't afford your accommodation because the rent's just gone hiked up and you've just lost your job or something, or whatever. There's a rent shortfall from Universal Credit. Then this would not be satisfied. Therefore, you cannot be found intentionally homeless. And then if we go down to 9.17, there's quite a few videos on the channel actually about intentional homelessness. So do check them out because I go into a lot more detail than I'm going to be able to do now. But 9.17, so basically an act of omission shouldn't be generally be considered deliberate where it was non-payment rent which arose from financial difficulties or benefit delays or whatever. So you can read it properly yourself on the screen. It might be you've got some issues around mental capacity. Might be fluctuating capacity. Similarly, you might have capacity issues that arise from mental illness or substance misuse problem, or the act or omission was made when the applicant was under duress, which basically means you've been forced into doing something bad. Now, as I say, do check Google or search for intentional homelessness on the YouTube channel because there's a whole bunch of videos which kind of look at these different things. But yeah, as I say, there are potentially some defences with some pretty plausible defences to make if you're being told you're intentionally homeless. So yeah, so in that section 184 letters that says you're in priority need but you're intentionally homeless, it will say at the bottom of the letter, if you get that far, if you don't agree with this decision, you need to ask for a review of it under section 202, which is the fancy name for it. And you do this by contacting this email address, whatever. So in that letter that you then write to the council, and if you've got 21 days from receiving the letter, so you need to be quick. So if you're running out of time, just send something in and then you can always add to it later. But basically, you need to say what it is you think the council has got wrong, or what they have, or what information they got wrong, what they didn't take into account. So some concrete things, not the fact that you say, oh, I didn't choose to be homeless. That's not what really the decision's about. It's about, was it reasonable to continue to live there? And did you do something? You might not have chosen to be homeless, but did you do something knowing that it might impact on your accommodation? So let's say you went to prison. Yeah, you didn't choose to be homeless. You didn't want to be homeless, but by committing a criminal offence, you must have known that you put your housing at risk. That would be kind of a genuinely intentionally homeless person. So yeah, let me just go back to the question, see if we've got anything else to say about this one. Yeah, so what to do next? Challenge it. Yeah, I think that's it really. Challenge it. If you're in priority need because you've got children, then the housing team should refer you with your consent to social services, who would in effect would have a duty to house you as well. But if you don't have children, then effectively the council's duties will end if you don't successfully challenge that decision. So now would be a good time to get a competent advocate or a solicitor. But you need to put in that challenge now so that you don't go over that 21-day deadline from receiving the letter. Shannon?
Yeah, I just didn't know whether it was worth the person also clarifying how long the local authority is going to give them to make arrangements to sort of find accommodation. Because that's something that might be worth doing as well.
Yeah, I mean, so they'll probably state, we're going to give you 28 days. In the letter that's kicking you out, they'll probably tell you that. And you can apply for more time, but
Yeah.
only if only if you've got exceptional circumstances, really. Um, Next question. If you're eligible and in priority need, can the council still refuse their duty to help you if you're homeless? No, they can't. So you just need to complain. If they're refusing to help you, and let's say I mean, I guess the one situation that this might be true is if you've made an identical application already, and then they found you intentionally homeless and they ended that duty that way, because you would still be homeless, still be in priority, you'd still be eligible, but you would not be able to make a repeat application to that council if nothing at all has changed. If anything, even kind of more than trivial has changed, you can make a fresh application, or you can apply to other councils as well. But most likely, that's just the council being just acting unlawfully. So again, complaint to the chief exec, copy in the relevant politicians, and make your case. Nice short bullet points or numbered points, even better probably. Keep it nice and short. Don't waffle on about kind of what happened 20 years ago unless it's relevant. Just keep it on point because you want people to read and understand quickly what it is, what the situation is. And again, as Shannon said earlier, get them to put it in writing. If they've said to you, oh yeah, no, there's nothing we can do, you need to get private rented, say, okay, great, put it in writing, and here's my email address, send it to me. So then you've got a written record of it. And if they haven't done that, then just keep emailing them back until they basically accept the duty. But a formal complaint, in my experience, is the only way to do that unless you can get a solicitor involved. So bear with me, my mouse has been weird. Next question, and it's another three-parter, I think. And there's a word that's been used here which I don't know what that means, so we'll have to come to that in a minute. Oh no, it's auto text. Yeah, that's fine. Cool. Okay, so I'm asking for a friend. He's 75 and lives with an underage family member. Does that mean under 18 family member? The private landlord now informed him that he intends to sell the house. My friend is really worried that they may become homeless. He is just able to afford the rent. He always pays rent on time. Can you please advise? So, okay, so if the underage person is a child and they're dependent on the 75-year-old, which sounds like it might be the case, they're automatically going to be in priority need. Doesn't sound like they're intentionally homeless, so they need to approach the council that they want to live in, or the district they want to live in. Let's keep it simple. Let's assume that they've got a local connection there. So let's just say they approach the local authority to where they're living, and just basically again just use that video I put on the channel. So that the one of the best way to make a homeless application, because it just spells out how exactly it is you want to kind of lay out the information. And I'm actually going to do a video about this soon about having teeth. So it seems like a bit of a random one to say about, but basically almost certainly the first argument you're going to have with the council is you send an email in which triggers the homeless application, and it does trigger the homeless application, but they'll come back to you and say, oh, you need to fill in a form, or you need to go on the council's website, and you'll get into an argument with them there and then. And you're in the right, so you just need to basically complain if they don't. I've got an example. I'm going to use a recent case I worked on where that's what happened, where basically the housing officer or manager by that stage just basically refused to take the application because the person hadn't done it a particular way. And I kept quoting the law to them and ended up getting them a lot of compensation in the end. But so it did take some time. But that's just something to bear in mind. So, yeah, at some point, generally in a homeless application process, you will have to have it out with the housing officer if they're doing things which are unlawful. And the only way you can really kind of win it is to basically is kind of do it via a formal complaint, which I'm also going to do a video about at some point soon because it's an important one. So yeah, does that, Shannon, anything else you'd add to that one?
just a really small point that obviously the landlord's informed him that he intends to sell the house, but doesn't say that he's actually served like any notice or anything yet. So it is likely if you go, depending on a local authority, just dependent on who you go to, but you could go and sort of ask now for advice and assistance and sort of see what they say and what they might be able to do earlier. If it's, a good local authority with very little housing pressure on them, we might be able to help out sort of sooner. But it's also likely that if you go and ask for help now, they're going to say you're not homeless, we can't help you, because that's technically true because you've not been sort of served Section 21 and you're not at risk yet. Um, so just to make that point, if they do fob you off now, it it could be legit. I mean, they still have the duty to provide advice and assistance. So, um, yeah.
Yeah, well spotted. So I'm going to take a bit of that back actually. Until a valid Section 21 notice has actually been issued, and it's within 56 days of that Section 21 expiring, then you can't make a homeless application. So Shannon says if you go before that, they'll just say, no, you're not homeless yet. There's nothing we need to do. If they're decent, they'll say, oh yeah, but when you are in that time, when that time comes, then we can do X, Y, and Z. And I guess also just to say 75 is likely to be in priority need in and of itself. It's not guaranteed. There's no set cut-off date for old age with priority need, but somebody 75, it'd be difficult to imagine that a 75-year-old, unless they're man-off fiends and they just cross the Antarctic, they're probably going to, not do too well if they're homeless.
With with that in mind, it's probably worth thinking not just about 75-year-old, but also the underage family members, sort of about housing needs in terms of like schools, locations, disabilities, anything like that. It's all worth sort of again just being prepared, getting evidence as best you can, getting assessments done, whatever it might need to be, and working out what impact those needs have on your housing situation. So then you can get suitable accommodation as well.
Yeah, cool. Question 12. Is there a forum you'd recommend for homelessness problems? So there are a couple of Facebook groups of varying quality. So there's one called Housing Advice Independent. Now there is an admin on that, which is really good, but there is a lot of just bullshit that goes on in the group. There's a lot of bad advice that's given, and the admins don't sort it out for some reason. But I'm not going to name the admin that's good, but there is an admin that's good. You'll also get there's basically it's like Pavlov's dogs. If you mention you're homeless, they'll immediately say, "Oh, you need to get private rented," even though most people have tried that already, and that's why they're kind of in the situation. So that's Housing Advice Independent. There's another Facebook group called Housing Advice UK, which is the admin's a solicitor who, as far as I can tell, actually, he'll offer his number out to people, and he'll sort them out. He does get a bit stressy with people asking the same question every time. So do read the kind of the rules of the group before you start, because there's some FAQs that you'll get annoyed if you ask the same question again on. But yeah, so I think those two. If you're a professional, we run a group called Homelessness Best Practice on Facebook, which again is kind of what if questions. Other than that, I don't know. I don't know of any other ones which I've heard people refer to or use. There may well be some out there. There might be some local ones which are great. Depends where you are. So yeah. Right. Let me see if I've missed something. So just someone making a point there. So not all councils do banning. Some say priority is given to whomever has been waiting in private rent the longest, irrespective of being classified as a priority and eligible for main housing dues. So yeah. So I'm interested to know if that person wants to say which councils they are. And my guess is it's going to be a London council, but I might be wrong. But yeah, I mean, the only rule that kind of governs Part 6 policies is that if you're homeless or in relief or prevention duty, you have to be on the register at some. They have to put you on the register in some banding, even if it's the worst banding. They just have to put you on the register. Okay, so I'm doing. So I think this is a similar question to what we've had before. I think it might be the same question. In fact, hold on.
Can I
This is
just jump
yeah,
in quickly to that forum one?
yeah,
Because although I know it's not what the person's asking, but there are lots of like co-production forums out there. And typically it's for when, you've gone through homelessness, you're out the other side, you're in settled and suitable accommodation. But depending on your local area, there is some local sort of co-production lived experience. expert by experience is all these different names for the same thing. That is a forum for people with lived experience to sort of try and tackle homelessness issues within either like a local area or a national area. So if that's something you're interested in potentially down the line, I know that's probably not what you're after now. But I've loved it and it's been really helpful for me on my sort of like lived experience journey and whatnot. So I just wanted to throw that in there. That's all right.
Yeah, and if you so where it's done politically, people with lived experience have a lot more power to their voice than they realise. It's very difficult for a councillor in a public meeting to just like shrug off what someone's just said about what's happening to them. So actually, we've said it before. If you get through being homeless in one piece, don't forget about your situation. Go and lobby your local council and basically get them to sort their act out. Because actually, a couple of people in an area can have a massive impact if you ask them the right questions and you know what you're talking about. So question 13, as I say, I think this is very similar to one we've had already. If you're homeless and eligible and priority need, then does your housing ban change to higher priority and point increase? As I said before, you've just got to read your local policy. I can't tell you what your local policy says. You'll have to Google it. So if you Google housing allocation scheme and your council's name, it should come straight up. So you just need to see, so somebody who's homeless eligible and priority need is going to be in relief duty. And if they're not intentionally homeless, then they're going to be in main housing duty. There will be a specific section in the policy which says what band they get. It just depends. As I say, sometimes it's better, sometimes it's worse. Have we done? I think we've done that one already. I think it was on the kind of multi-part one. So what if I was a refugee and I got a letter of expulsion and I have severe depression and taking medication? So when you say letter of expulsion, you need to explain what that is. Does that mean you've been evicted from the temporary accommodation? Or is it something related to the refugee process I've not heard of before? So might just need that clarified. So I'm going to take that question off until it gets clarified, if that's okay. Just because I just need to know what a letter of expulsion actually is or what it actually said.
Or where it's from. It's
Yeah,
probably quite helpful
yeah,
as well.
yeah. So question 14, can a landlord be sued for disrepair after they fix the issues after many years? So don't know. Will would be the one to ask, and he's not around for 2 weeks. I think the answer would be yes, but I don't know for sure. And what I do know is and I only know because Will told me, is that you can't get legal aid for disrepair cases. You have to basically pay for it yourself. I'm not quite sure how you do it, but it's not something you can just get a legal aid solicitor for, even though there's potentially a lot of money involved. Like I've seen, tens of thousands of pounds in some extreme cases. So yeah, all I can say is come back in 2 weeks and ask Will directly, and he'll tell you.
In the meantime, Housing Ombudsman website might be some use here because they deal a lot
Yeah.
with like Part 6 disrepair stuff. So they might have some guidance and advice there.
Yeah, so the housing ombudsman and the local government and social care ombudsman are two different things. So they're both similar in terms of what they do. They're both good. But housing ombudsman would look at. I actually want to just hazard a guess and say it's only social housing or council housing they have a kind of they do deal with. I would imagine Shelter's website has also probably got some good stuff on there as well. Shelter's website's pretty darn good. So yeah, again, I'm probably going to take that one off because we haven't actually answered it. So sorry about that. So if you want a good answer, come back in 2 weeks. Or I'm pretty sure Will actually answered it last week or the week before. So if you go onto the YouTube channel in the live section, I basically put the questions in order so you can kind of get an idea of whether it was asked or not. So let's try question 14 again. Right, so just that there's a person asked a question that's got personal data in it. So if you could just reword that'd be awesome. I'm just going to remove it for the time being. Why? So I don't know the answer to this, but it's an interesting question. Why are housing associations putting a ridiculous number of occupancy on bidding advertisements? I don't quite know. I mean, number of occupancy, as in like how many people are going to fit into a property. I don't know is the answer. Again, I'm going to take it off again actually because I haven't got anything useful to say. Shannon, I don't know if you can decipher that, but I don't know if that is that saying, this two-bed property would be great for 10 people. I'm not quite sure what they're talking about there. Again, if they want to clarify it, I'll stick the questions in. But in the meantime, there's just a question here, which seems to be pretty straightforward. Does the family have the right to ask for a housing plan example? Or can they request a 4-bedroom ground floor ground house with a garden for a family of 4? They can always request it, unless there's a very good reason they're not going to get it, unless they get lucky. So let's say, for example, you had children who had a very specific disability or something that needed like a garden, then yeah, that'd be absolutely good shout. But if the council will just say, unless there's that kind of need to do so, they will allocate properties, as they kind of need to kind of through their policy. So it's possible you'll get a house with a garden, but it's not something you can guarantee getting. You can't make them give you one unless you've got a kind of that kind of disability element to your kind of family circumstances.
I guess a disability element that's relevant to needing outside space as well, because not all of them would be. But
okay, so there's just clarification on that. So again, I'm just going to put this in. It's an interesting question. I don't know the answer to it. There's a clarification. So, I mean, my guess is that social housing is basically constrained by the overcrowding calculation that you can do. Shannon knows more about it than I do. But basically, so there's kind of a set number of bedrooms you can have for different sizes and different makeups of families. So there's also like a the actual square footage of the room and stuff. But let's say, for example, if you've got 2 kids under 10, they'll be expected to share. So my 3-bed maximum of 5. I would say, so a couple, and then 3 children. That would not be that could well be legit. It just
also,
depends on.
often living room spaces can count as a bedroom. So in terms of the occupancy, it would affect not the number of bedrooms, but they could be saying 3-bed, maximum 5, because actually they're realizing that another person could stay in the living room. But yeah, if you had, say, 2 people in one room, it also would be suitable for a lot of setups.
Yeah, I think that last sentence might just kind of change the angle of the question. So I've just seen it. So, or 4-bed maximum. What happens if you have so basically, I think what the question's saying is, if you've got 5, if you're a couple with 5 kids, or couple with 4 kids, and you're pregnant or something, does that mean that the housing provider is going to basically refuse your property? Now, I don't know the inner workings of housing associations basically. So, but my guess is they would know it would be stupid to put a family into a property that there's then going to be overcrowded the next year. If again, it just depends on the policy. Being overcrowded in itself doesn't mean that you're going to be homeless automatically, but it might well mean that you'll get onto the housing register at band C or whatever, band D maybe, or equivalent. So yeah, so I don't know. Interesting question. I'm going to leave it up there. If anyone's got any better answers than we have, then feel free to share them on the chat. But my guess is they are constrained by some rules on it, and there might be some kind of policies about placing growing families in accommodation that's going to be unsuitable for them a couple of years down the line. I don't know. So questions from the week. Shannon, if you need to go, I've just seen the time overrun again. So there's just some questions that come in that are they're not anonymized, but I'm going to put them at the end here. No, not that one. Done that one. Hold on.
There is one more in the live chat that I think you've missed. It's an additional question to the 75-year-old one.
Oh,
you do that.
I can't see that. I saw it a minute ago. It might have been. I literally can no longer see it. Shannon, if you want to put it in the Zoom chat, and I'll copy it across. Yeah. Yeah, it's weird. Oh yeah, I know. Okay, yeah. So yeah, question makes sense. Hold on. So I think as we kind of, I'm just going to stick that back up here then. So I think
we kind of answered it, but it's probably good to clarify, isn't it? Because
So can you additional question? Can the 75-year-old apply now, even if the house has not been sold yet? So they can make a Part 6 housing register application now. They might get knocked back. There's nothing to lose from it. But if they make a homeless application now before the Section 21 has been issued, and it's within 56 days of the Section 21 expiring, then the homelessness team will simply say you're not homeless and you're not threatened with homelessness. So there's nothing we actually have to do. Now, as we said already, a good housing officer will still give you some advice and assistance around that, but they don't have to do anything until the landlord has served that Section 21 notice and it's valid and it's within 56 days of expiring. Which, given that they have to be 2 months, it's not going to take long for it to be within 56 days. So yeah, right. Here we go from the questions for the week. So I got a possession order from the court. I already told to the homeless team. The officer said you can't get council house. You need to live private. If you don't, I'm going to close your application. So this is potentially legitimate. So when you make when you're in, I guess here we're talking about. Okay, let's just break this down. So I'm not sure whether this person's in prevention duty or relief duty. They should be in the relief duty at this stage because the possession order's already happened. So they're in relief duty. So the council satisfied they are homeless and they are eligible for assistance. The council then do an assessment of your circumstances and they do what's called a personalised housing plan. And in the personalised housing plan, they will say you must look for private rented accommodation. And I have heard of housing officers doing this, where if you basically don't comply with that instruction to go looking for some stuff going on in some room right now, but if you don't kind of cooperate with the personalised housing plan, then they will say that you've unreasonably and or something refused to cooperate with them, and I don't think they can't. Let me just find this out because they can't. I don't think close the homes application down in some circumstances. But let's just go back. So it's in chapter 14, somewhere around here. So it's the last. Yeah. So no, not that one. Let's put the last one. Yeah, that's okay. So here we go. Yeah. So deliberate. And so basically, refusing to look for private rented accommodation could be seen as a deliberate and unreasonable refusal to cooperate. And so the provision duties and relief duties can also be brought to an end as a result of the applicant's deliberate and unreasonable refusal to cooperate. For further guidance on non-cooperation, see chapter 14. This is chapter 14. Idiots. Why couldn't they get that one right? Where the prevention duty is brought to an end due to deliberate and unreasonable refusal to cooperate, the applicant's entitlements under other sections of Part 7 are not affected. But so if you're in prevention duty still, then not cooperating doesn't change anything down the line if you have to become homeless. Where the relief duty is brought to an end as a result of the applicant's deliberate and unreasonable refusal to cooperate, the main housing duty will not apply. However, effectively what this is saying is that they will basically, instead of giving the main housing duty, they'll give a final accommodation offer or a final Part 6 offer. So even if you're in priority needs, you're homeless, you're eligible, you're not intentionally homeless, but you refuse to cooperate by you don't go looking at private rented accommodation, then the council they're still going to owe you a duty at the end of it. They can't just stop the homeless application. However, if you're not in priority needs, they can end the relief duty. They can stop that process happening altogether. So I could go into a lot of detail about how or when that's kind of worth bothering about. Again, I've done some videos in the last 4 months on the YouTube channel about that in more detail, so you might want to go and check them out. But that should answer that question. I can hate the relief
I feel like
duty.
screenshots of like Rightmove would be sort of good to be like, I'm cooperating, I'm looking for private rented, but look at the prices on Rightmove of all the private rented. Do you know what I mean? Like, and if they go, actually, this is how you need to look for it, then cool, like do that. And it is a bit tick boxy, but if it gets you out of that sort of lack of engagement rubbish, then it's probably worth doing.
Yeah. So next question. There's one more from the week, and I'll see if there's any on the live chat still. So I've received by the way, guys, if you find this interesting, do give the video a like, do share it or whatever if you can be able to share it. If you haven't subscribed already, do subscribe. You'll get notifications of new videos. Worth doing. I'm going to put some new ones out in September when I get around to it. Anyway, question 17. I've received an order of possession, Section 21 notice, so the Section 21 notice is not the same thing as an order of possession as far as I know. It's an order of seeking possession, but it's not a possession order. Anyway, from the court, and I should move out by 31st of July. I don't know when this came. Okay. I'm still in the flat. says on my contract that I should pay rent on the 5th of each month, as my landlady is likely to take the matter to the High Court. I don't know why the High Court. She's keen to sell the flat. I'm concerned that bailiffs may be coming soon. Should I therefore still pay her a month's rent as I've done for 15 years? So there's an interesting question here because legally, yeah, you've signed a contract saying you'll do it. So if it was me, I would do it. But it seems to be not kind of controversial for people in this situation to say, do you know what? I'm not going to pay the landlord this month. Instead, I'm going to use that money to secure alternative accommodation for me somewhere else. And if and the worst comes to the worst, the landlord will pursue me for that money and I'll have to pay it back at a later date. But that person needs the money right now to get a deposit for another flat or something. So I think the legal answer we have to give is, yeah, you should pay it because you contracted to. But certainly, it seems to be pretty common practice and an accepted practice where someone in that situation would save the money for actually finding alternative housing. And I guess that some landlords would basically say, do you know what? I'm not going to pursue you for it because you've saved me the court costs, you've saved me all that hassle by doing that. But again, that's you're gonna have to make a decision on that if you just sign that contract. And then the final question from the week. So I'm currently living in my car. Got a bad gambling addiction I'm working on. Been in my car for 2 weeks. Had the first assessment, I assume, at the council's homeless team. After filling out the homeless prevention form, that's not really a thing, but yeah, okay. I get it. So the officer told me because I make a decent wage, I won't be getting any temporary accommodation. I think that means all of that before even looking at my supporting documents. I submitted all documents. What's your view on my situation? So certainly our society's understanding of gambling has come a long, long way, but we're not yet. I'm not aware of any cases I can recall where it's mentioned in housing law yet. No, there are cases which mention drug addiction or alcohol addiction or whatever, but gambling addiction has not kind of got that position into housing law yet. And so what that means is, although you might have a good case, the reality is that it's going to be very difficult to argue that without without getting a solicitor and basically taking it to court and being the first case to argue that gambling addiction can leave you vulnerable, because that's the key question: is, are you vulnerable? That's what's going to make you in priority need or not. And the fact that you're working, the fact that you're earning a good wage would be mitigating factors against being vulnerable. So it's not that you wouldn't be vulnerable because of those reasons, but it would be kind of leaning against being vulnerable. But yeah, so I think, yeah, I mean, there's if you're not already, there's some good gambling charities, gambling support charities out there. GamCare is, I think, one of many, probably they're out there. So you might be able to get some support there. It may well be that the gambling's having a big impact on your mental health as well. Would be surprising. So in one sense, your gambling might not be enough to show that you're in priority need, but it might be that the gambling's leading to anxiety and depression and stuff, which could well lead you to be in priority need. Just depends on the severity of it. So I think that's how I'd really take it. But I think yeah, as I say, it's kind of it's something which I think we'll see in case law in the coming years, because yeah, as I say, we're kind of growingly, we're increasingly recognizing gambling addiction as being a real thing. But I don't think we're there yet within housing law. As I say, I'm not aware of any cases which have kind of been based on a gambling addiction being, meaning someone's in priority need. So that's all the ones from the week. And then if we go back to the live chat, let's see where we got up to.
Just to add one small thing, because I'm aware the time's getting on. Just be brutally honest in any expenditure and income forms as well. Because at some point they probably request your bank records anyway, so they'll probably see a lot. And just when you're filling in the sort of like forms to work out how much you can afford and stuff, just be honest with what you are spending on gambling and whatnot. Yeah,
cool. Next one. So friends live with their elderly mother in housing association flat for 15 years. The tenancy states he would acquire the property if she sadly died, but now moving to care home and he is homeless. So okay. I don't know is the answer. My first guess would be, potentially he would be homeless now and there would be no right of accession onto the tenancy. I would assume that would have been discussed, advised when the housing association made that move. So I don't know, they might have given something in writing already. he would certainly be able to make a homeless application on his own. But then the questions of whether he is in priority need would apply, as it always would do. Guess it sounds like he's going to be eligible for assistance, but I think that's going to be the situation. So I did a video maybe a couple of weeks ago about, what if you're not in priority needs. So it kind of outlines what support you should be able to get. But certainly, I guess making a homeless application now, and part of that assessment and part of that advice and assistance you get would basically say what your rights might be and whether you do have any. The council is actually pretty, could probably be trusted to actually give a good answer about that, because they're motivated to get you, basically get rid of you. And if they can do that by getting the housing association to give you a tenancy, then they'll absolutely tell you to do that. I've worked in cases like that before, where suddenly the housing officer becomes your best mate because they want you to, they want the housing association to pass the tenancy on. So yeah, Shannon, you got anything to add to that one?
Nope.
Okay. There's a few questions on here which they're about kind of ownership of property, like probably more from a landlord point of view. Things which, yeah. I'm just trying to get my head around that one actually. In the meantime, what's this one here? Hold on, let's put this one in. What is taken into consideration when the council is issuing a property to a family with children? What should be taken into consideration is the needs of any household members. So, as I say, if they've got any kind of special needs or anything like that, the location of school should be taken into account. The support network to some level should be taken into account. The location of employment, that should be taken into account. But if there are no disabilities, if the property is big enough for you, then that's really the end of. So it could, there's no reason why a family couldn't be placed into a flat in a high-rise block. There's nothing stopping that happening, unless there's kind of some sort of Equality Act issue at hand. So councils absolutely can discharge their duties into flats for families. It's not ideal, obviously, but it's something they can do legitimately.
And even with schools, potentially it would be reasonable for you to move your children's schools for the location, depending on their age and stuff. So yeah, when we say consider like school distances and stuff, it doesn't necessarily mean they won't expect you to move your kids' schools.
Yeah, I've just removed a question in there which is written like had personal data in it. So again, if that person wants to rephrase their question as a what if question, I will try my best to come to it in a minute. So yeah, this one, I'm just trying to work out if we can actually answer this one. Is there ever been a possibility of the owner of emergency accommodation property on license agreement might sell to the council? The answer to that is yes, that can happen. Is there ever been a possibility the owner of a emergency accommodation property and license agreement might sell? Sorry, I've just done that one again. There's another part to it, but that's not the right bit. Let's get this right. Delete. Cool, getting there. The owner had brought off auction recently and then gave to be managed by the council. Emergency temporary housing, a house is sold to the council, would occupiers get first? No, they wouldn't. So it's very unlikely. I mean, it's technically possible, but there would be no priority that the current licensees would get. In fact, the council, if they're going to turn it into settled accommodation, they probably want to do some work on it anyway. So they probably want to get you out and then kind of get it sorted out before they re-let it. So there'd be no, I mean, as I say, it could happen. There's nothing stopping the council doing that, but it's unlikely in my experience for them to consider that. In fact, you're right, there's another one with personal data. So, okay, what we're going to do, guys, we've run out of time, I think. So for those guys at the end who put personal data in there, if you want to rephrase your questions for the live stream next week, we will try to get around to it. Again, it's not me being difficult. It's about protecting your personal data, which you need. I guess I'd love to see people really kind of enjoy their rights as people in the country, because that's why the law's there. So it's a good kind of mindset to be in. A second, it's a good way to kind of extract the important information you need to get a sensible answer. Otherwise, we kind of get you tend to get quite long questions which are kind of wrapped up with the emotions that come with it all as well, which doesn't help us give you a good answer basically. So yeah, we're going to call it a night for there. I think my head's probably a bit too frazzled, Shannon, to even talk about this writing stuff. I guess, I mean, I say a couple of things out there. If people agree or not, I don't know. But think some of the anger that we've seen in this last week, you know, I think when we talk about council gatekeeping and inadequate housing supply and stuff, that does play a part in kind of fueling the anger that people have. No, I'm not obviously not kind of saying that people should be going around looting Greggs and whatever they've been doing this week, but I think for me, like, it's been really sad to see basically, you know, no one really kind of actually listened to either side. And it seems that you know, when you are kind of systematically denying housing to lots of people, yeah, you're gonna foster a lot of ill will, which then gets directed at immigrants, which I don't think is you know, logical, let alone good. I think we should be angry at our government for not building enough houses over many decades. But yeah, I don't know if people have got thoughts about that. We'd be interested to not only know what your thoughts are, but I guess also just kind of hear from you about how the topic could be broached without it being, you know, making things worse, really. But yeah, so I'll leave that there. Shannon, if you've got anything to say about that one.
I don't think so, to be honest. I think it's worked my head this week a bit. And certainly put me in quite a reflective state of just the way that we have discussions about things and the potential like tokenism within the sector. And I kind of feel for everyone involved. And I feel like the real issues, which is probably, you know, like you say, people being denied their rights, isn't actually coming to the forefront. And I'm not a fan of violence or anything or racism or anything at all. And it's wrecked my head, and everything I've seen sort of makes me feel quite sick. And I've seen also lots of talk about standing in solidarity with each other, and I've seen some really sort of, I guess, heartwarming videos this week. But I think for me, there's some frustration around the heartwarming solidarity stuff being words. And I think actually, particularly in regards to housing and stuff, we need more than that. Like, if we're going to stand in solidarity and what have you, and it's a word that gets thrown around quite a bit, I think, at the moment, but we need to be acting together, and listening is an action, and actually listening with like open ears, which I know sounds really stupid, but you know, that whole like listening to learn, not listening to just respond, and sort of listening to get your point across, I think is really vital at this point. And obviously I just want everyone to be safe, which again, I feel really naive saying that, but like I do.
Yeah.
So yeah.
Yeah, there's certainly been, yeah, I don't know how much to go into now. I probably can say a little bit more about it. So I did a video a couple of years ago because there was a big kind of campaign for support, don't report, which is kind of, I'm all for, don't get me wrong. But like the same charities that were kind of writing bold letters to the Home Secretary at the time were completely silent about gatekeeping to people with recourse to public funds. There just seems to be some real kind of like hypocrisy and kind of virtue signaling stuff going on there, I think, where charities get a lot of, you know, kind of reach on social media by saying these things, but actually, are they willing to tell the government to stop? You know, or even their local council that funds them, are they willing to go up against them and say, actually, you know, your behaviour and your actions are kind of causing a lot of hurt and a lot of pain across the country. So anyway, yeah, I'm not going to go too much into it, but yeah, no, cool. Thanks, Shannon. Thanks, everyone, guys. So yeah, keep the questions coming in. As always, you know, questions are coming on the channel during the week. I'll kind of have it lined up. Again, if you can just put questions in the third person or about, you know, what if questions, whatever, that makes it easier for us and safer for you. But other than that, I hope you guys' situations get better. And just, yeah, as we always say, don't give up, and just don't forget that councils can be challenged. You know, that's the key thing. You know, they kind of act like they're kind of, you know, law lords or whatever. They're not. They often don't know what they're talking about, and you can just, you know, kind of unpick them if you just follow the process, just complain, and just kind of keep it all nice and methodical. So yeah, good luck to you guys, and we'll see you next week.